Mr. Moses was making demands that the children walk around the house and show him things.
The Moses case, and I believe Ms. McLean and Mr. Zandy are present.
Yes, Your Honor. And I had submitted an updated set of orders. The way that
I don't know why the audio itself isn't working, and I don't have headphones for this.
All right, so if you're not in front of the court right now, please mute. I've muted folks. Okay, go ahead, Ms. McLean.
So they would be dated December 4 on my signature line.
Okay, I do have the December 4th order. And I believe the parenting plan was attached to it with the same date, December 4th.
Correct.
Okay. And Mr. Zandy, I didn't see your signature. Have you had a chance to review those?
I did, Judge, and I appreciate Ms. McLean making the majority of those changes. There just needs to be a little bit of clarification on the telephone contacts and better definition of that. And I think that's the only real issue today.
Okay, great. Let's turn to that then.
That's going to be in the parenting plan at paragraph 14. Page 10. And I added the language about neither parent shall interfere with the child-directed phone calls.
Okay, sorry, just flipping there. There we go. So subsection H, child-directed liberal telephone privileges initiated by the children with the parent with whom they are not then residing. Without interference of the residential parent, the children shall choose how long they wish to talk on the phone. Neither parent shall interfere with the child-directed phone calls. And so, Mr. Zandy, what is your request for clarification or edit?
Well, it's twofold. Number one, I would just like a provision in there that both parents are to cooperate in good faith to accommodate that provision. Obviously, these are two young boys, which is going to require good faith efforts on both parties' behalf to encourage the children to reach out to the other parent. I think that's important, especially given some of the volatility that this case has had over the recent past. Secondary to that, we would also like to include FaceTime or some other electronic means for the boys to actually see mom and dad's face on the phone. And again, I think the age is important in considering this request, given the fact that, you know, simply talking on the phone for these two young men is probably a little bit more challenging than actually seeing mom or dad on the same device and see their face and connect in that manner. I understand the GAL from past communications is not opposed to that. I think given the fact that we live in 2023 and we have that type of technology available to us, it's probably beneficial for everybody involved. Most importantly, these kids to see mom and dad's face and blow them a kiss or actually see the mannerisms, as opposed to just hearing a phone voice on the phone. So we do ask that you include FaceTime as part of the quote unquote telephone communication, as again, I think that certainly promotes these kids' interests.
Ms. McLean, what is your client's position on first inclusion of a sentence that would be, good faith by both parents to accommodate or accomplish the telephone calls, and then I'll hear on your client's position on FaceTime.
Well, I think that the good faith is embedded in the requirements as far as the parenting plan and the other provisions that they're not to interfere with the parenting of the other and the like. So just to provide that individually for phone calls, one that wasn't argued at the time of the hearing. And the video chats were not argued at the time of the hearing. We're here for presentation from what your order was, not to rehash issues. But in any event, if the court thinks that there needs to be that language included, that has not been previously included, and there hasn't been an issue that has been cited as far as the sufficiency of telephone visits. So I guess I'll leave that up to your honor's determination on whether now, after a year and a half or more, we need to add that language. regards to the video chats or the FaceTime, first off, the children's own devices do not accommodate video chat or FaceTime. There has been in the last, well, since the orders have been entered, which I think were early 2022, so almost 2 years now, there has been one video chat that was accommodated on my client's phone, and that did not go well because Mr. Moses was making demands that the children walk around the house and show him things. And it's contrary to your ruling on reserving the request to restrict screen time during Mr. Moses's time. It's contrary to Ms. Rosen's request that these parents reduce these children's screen time, one factor of which my client has been following. Third, it would require that the children then access either a separate computer or my client's phone in order to accommodate that. In the past 2.5 years, this has only occurred once. So our position is that that should not be required, as it adds further complications. These kids are older. They clearly know who their dad is. They see him in counseling sessions. They see him every Wednesday. They see him 2 to 3 weekends a month. So they're going 3 to 7 days without actual visual contact, but that doesn't include the counseling. So when he's having contact with them in counseling sessions, it's even less time.
Okay. Ms. Height, any particular input as it applies to the video calls / FaceTime?
Thank you, Your Honor. I think video component of a phone call these days is a fairly normal part of a phone call. I don't know what their accessibility is as far as what devices they're using. My stance would be, Your Honor, that it's not required that they have the face video part of the phone call, nor would it be forbidden if it's convenient to do it. I don't see a deficit to doing that.
Okay. Here's going to be my ruling on this, and this is based on the parties' arguments, Ms. Height's input, and just general common sense as an adult navigating these things in 2023. I don't see, frankly, I don't think kids these days, as someone pointed out, see much difference between hitting FaceTime and hitting call. It's the same thing to them. I do think that FaceTime for kids is more valuable because they do see who they're talking to. They see the facial expressions. I frankly think it's a great way for the kids to stay connected to both parents. I don't think that I am going to allow FaceTime and video calls at the child's request. If they prefer to make the FaceTime call instead of just the phone call, they should be allowed to do that. I think it benefits both parties. I don't think this is favoring any particular party versus another. So I am going to allow FaceTime and or video calls at children's request. Obviously taking into account if there are, if the residential parent is on the road, maybe that's not going to work so well, those sorts of things. But I do think it will be allowable. It just won't be, I guess, mandated. But my hope is that if the children request to see the non-residential parent, mom or dad, on video, that they be allowed to do so.
May I ask a clarifying question on that?
Absolutely.
So since they're child directed, let's say the children call one of the parents, is that parent able to say, you need to FaceTime me and end the call and demand that they do that?
I mean, do we think that that's going to be an issue?
Yes.
My question.
Yes.
Well, and that kind of leads to sorry, Ms. McLean, I don't know if you're done or not.
No.
Yes, I think that's going to be an issue.
So I think that goes to the second part of that, which is the policing matter of this, which is why I think both parties operating in good faith is important. Again, we would hope that someone would as parents, just be agreeable to that and do the right thing. Unfortunately, there's been some reluctance to do that. There's been a complete swearing match as to what's happening with these. I think anytime you have kind of these liberal child-led type orders, that leads to some potential abuses. Kids should have ready access to both parents. If they want to have the FaceTime or electronic means, they should have access to do that. But again, we're talking about younger kids. We're not talking about teenagers who are going to say, Dad or Mom, I want to see your face. I think we don't have to define it. I certainly think the court's order, it makes good practical sense in this. I just don't want to go a period of time because one parent or the other is withholding the phone from the kids, not encouraging phone contact. And we're talking about two kids who are of the age where probably they may or may not even think about that, whether they have access to the rights to Mom or Dad, or whether they've even historically asked to speak to Mom or Dad on the phone. So we're starting to get into a little bit of an area of gray with that, which is why I think it does fall on the parents to act reasonably, to act in the child's best interest, and allow free, unhampered access through FaceTime so that they can, again, see Mom or Dad and know that Mom or Dad is going to say, good night, buddy, love you, how was your day at school, etc. All those types of common communications, which is, again, dovetails into the both parties cooperating in good faith to make sure that the kids know that these calls and FaceTime chats are available to them. So from a policing issue standpoint, I think that becomes the issue.
Yep.
And again,
Yep. So here's what I'm going to do. I mean, I think we're making a mountain out of a molehill here, perhaps. I am going to put in that each parent shall exercise good faith in accomplishing the telephone visits, FaceTime and or video calls at children's request allowed. I'm not going to go further than that. If this becomes an issue between the two parents, I guess note it back on my docket and I'll deal with whatever specific issue comes up. I hope this isn't an issue. My overarching goal with this, as I said, when I made my initial ruling, was that this is maybe the one area in this separation that the children have any sort of say or any sort of control themselves. Everything else is being dictated to them. So my real hope is that this is a child-led process with the phone calls and video visits. If the child hits FaceTime and the other parent picks up as FaceTime, perfect. If the child hits snail mail call without video, then that parent picks up the snail mail call without video. So I don't think that it needs, I guess if it comes back to me as an issue, my number one question is going to be, what did the child ask for, or what did the child initiate? Because at 8 and 6 nowadays, they're very familiar with FaceTime video calls. So I think if they want it, they know how to do it. And that's going to be my ruling.
all right, thank you.
Very well. Thank you, Your Honor.
I would hesitate to file that kind of a motion because it's pretty, a serious allegation. However, the minor child in this case spoke with his father and indicated that the referee's son is in his same grade, attends the same school. He's very good friends with him, has met the referee outside of school. It's unimplied that he felt that he had this relationship with the referee that would have had an impact on the case.